It's been nearly a century since the federal government put strict limits on a tool meant to make gunfire quieter.
It has been almost a century since the federal government put strict limits on gun suppressors.
It makes all of us less safe. We need universal background checks.
We've done $750 million just for school security since 2019.
It's outrageous that they would spend $1.4 billion to make silencers cheaper.
Removal of the excise tax cost American taxpayers $1.5 billion.
But the American people are 70% for banning various weapons that are assault weapons.
A unanimous court just ruled that NFA suppressor regulations are unconstitutional under the Second Amendment. Unanimous. Not a split decision, not a narrow majority. Every single judge on this panel agreed that requiring you to register, pay a $200 tax stamp, and wait months for government permission to own a suppressor violates your constitutional rights. And this decision dropped immediately after the Department of Justice, the same DOJ that has spent decades defending these regulations in court, reversed its own position. It essentially admitted the government's legal argument was built on sand. I'm going to break down exactly what this means for you, what it means for every NFA item you own or want to own, and the one part of this ruling that nobody is talking about that could be more important than the decision itself.
Some changes have been made to the massive tax, including ones that would loosen regulations on gun suppressors.
It's outrageous that they would spend $1.4 billion to make silencers cheaper.
Act would prohibit the sale, transfer, production, and possession of gun silencers.
It has everything to do with making money for a certain segment of the gun industry.
All right, so let me tell you why this matters to you personally right now. If you own a suppressor, if you have ever filed a Form 4, which is the ATF transfer application for NFA items, if you have ever sat through that soul-crushing 6-month, 9-month, sometimes 14-month wait just to take possession of something you already paid for, this decision is aimed directly at the regulatory framework that puts you through that process. If you have been thinking about buying your first suppressor but the $200 tax, the paperwork, and the wait time kept you on the fence, the legal ground underneath that entire system just cracked wide open. And if you own any NFA item, a short-barreled rifle, a short-barreled shotgun, anything registered under the National Firearms Act of 1934, pay close attention. The constitutional reasoning in this ruling does not stop at suppressors. It reaches into the foundation of the NFA itself. This is not a minor procedural ruling. This is the most serious constitutional challenge the NFA has faced in its 90-year history, and it just won.
It's been nearly a century since the federal government put strict limits on a tool meant to make gunfire quieter.
It has been almost a century since the federal government put strict limits on gun suppressors.
Justices have ruled that people who are under domestic violence restraining orders cannot possess a firearm.
High Court ruled in favor of a federal law that prohibits people under domestic violence restraining orders from having guns.
Here's the breakdown of what actually happened and why the legal mechanics matter. The case centered on a challenge to the NFA's regulation of suppressors under 26 U.S.C. Section 5845. That is the section of the Internal Revenue Code that defines what counts as a firearm under the NFA and subjects those items to registration, taxation, and the entire ATF approval process. The challengers argued two things. First, that a suppressor is not a firearm. It is an accessory that attaches to a firearm and reduces the sound signature when you fire it. Second, and this is the constitutional kill shot, they argued that even if you accept the NFA's classification of suppressors, the regulatory framework that the NFA imposes, registration, tax stamps, months-long approval processes, fails the test the Supreme Court established in New York State Rifle and Pistol Association v. Bruen. That is the landmark 2022 decision that fundamentally changed how every firearms regulation in America gets evaluated. Under Bruen, any regulation that burdens conduct protected by the Second Amendment must be justified by a historical tradition of analogous regulation from the founding era. That is not my opinion. That is the Supreme Court's binding standard, and the court in this case applied it honestly.
Over 400 silencers were found on or traced to violent crime scenes in 2023 alone.
History of the United States Department of Justice, you now have them stepping in preemptively before a bill actually becomes law.
Removal of the excise tax cost American taxpayers $1.5 billion.
The law makes it a Class 1 misdemeanor to make, sell, buy, import, or transfer an assault firearm.
The unanimous panel looked for any founding-era tradition, any historical analog at all, of requiring American citizens to register firearm accessories with the government, pay a tax for the privilege of owning them, and wait for bureaucratic approval before taking possession. They found nothing. Zero. No founding-era regulation that looks anything like what the NFA imposes on suppressor owners and under Bruen. When the government cannot produce a historical analog, the regulation fails. Period. That is not a close call. That is the framework working exactly as the Supreme Court designed it. Now here's where the DOJ reversal comes in and why it is so significant. For decades, every administration, Republican and Democrat, sent DOJ lawyers into federal court to argue that NFA regulations were constitutional. They argued that Congress had the authority to impose these restrictions and that the Second Amendment did not prevent the government from requiring registration and taxation of suppressors. That wall of institutional legal defense just collapsed. The DOJ reversed its position in this litigation and acknowledged that the constitutional arguments against NFA suppressor regulation have merit. When the federal government's own lawyers stop defending a law, courts notice. It does not automatically mean the law is dead, but it removes the single most powerful advocate that law had in the courtroom.
Department of Justice threatening to sue Virginia if Governor Abigail Spanberger signs a bill aiming to restrict guns.
Virginia Governor Abigail Spanberger signed a series of gun control bills toughening a proposed assault firearms ban.
With the last administration, when you saw a weaponization of this department, the likes of which had never been seen in history.
I can't believe what this new Governor Spanberger has done to the Commonwealth. People that voted for Spanberger are saying to themselves, why did I do that?
Let me give you the context that makes this even bigger. This decision does not exist in isolation. It sits in the middle of a post-Bruen legal revolution that is systematically dismantling firearms regulations that have no historical foundation. Think about what has already happened. In District of Columbia v. Heller in 2008, the Supreme Court confirmed your individual right to keep and bear arms. In McDonald v. City of Chicago in 2010, the court applied that right against state governments. And in Bruen in 2022, the court gave that right teeth by demanding historical justification for every regulation that burdens it. Each of those cases built on the last, and this unanimous suppressor ruling is the next brick in that wall. There are cases moving through the federal circuits right now challenging magazine capacity bans, assault weapons bans, and other restrictions under the exact same Bruen framework. What happens with this suppressor decision on appeal will directly influence every single one of those cases.
To make it illegal to sell, buy, import, make, or transfer assault weapons in Virginia starting July 1st.
It makes all of us less safe. We need universal background checks.
In the Commonwealth, we know far too well the horrors of gun violence that impact our communities.
She's a leftist, and she doesn't like guns or gun rights, former CIA operative.
Now, let me be honest with you because that is what this channel is about. Is this a total victory? Not yet. This is a lower court ruling. It will be appealed, and there are legitimate legal questions that higher courts are going to have to work through. Critics of this decision argue that the Bruen historical tradition test is being applied too rigidly. They say the framers could not have anticipated suppressors or the specific categories of modern weapons the NFA covers, and that some flexibility in the historical analysis is necessary to allow Congress to address genuine public safety concerns. That argument is not frivolous. It represents a real tension in how Bruen gets applied going forward. The Supreme Court is eventually going to have to draw clearer lines around how much analogical flexibility the test permits. And here's the part that I think matters most for the long game, the part that almost nobody is covering. One of the judges on this unanimous panel wrote a concurrence. That means the judge agreed with the result but wrote separately to say something the majority did not. That concurring opinion argued that the court should not have stopped at Bruen. That judge said the NF's registration and tax stamp system is independently unconstitutional as a prior restraint on a fundamental constitutional right. Think about what that means. A prior restraint is when the government requires you to get permission before you can exercise a right.
It's like banning cars. Cars kill more people every year than firearms.
People who had been deemed dangerous because they had domestic violence restraining orders cannot possess firearms.
The universal background checks we ought to do right now. Banning bump stocks we ought to get done immediately.
After legal back and forths for years, this is now in the hands of the Florida Supreme Court, and they could vote soon.
We would never tolerate the government requiring you to register, pay a tax, and wait for approval before you could publish a newspaper or attend a church service. The concurrence says the Second Amendment deserves that same level of protection. It says the NFA's entire permission-based framework is constitutionally offensive regardless of what the historical tradition shows. If the Supreme Court ever adopts that reasoning, it does not just end suppressor regulation, it puts the entire NFA, every Form 4, every tax stamp, every registration requirement under existential constitutional threat. That concurrence is a legal time bomb, and I'm watching it very carefully.
You had this department who stood idly by while states tried to keep President Trump off the ballot.
But the American people are 70% for banning various weapons that are assault weapons.
Congress should also pass safe storage legislation to protect kids from being harmed by loaded weapons.
Weapons similar to those I carried in Iraq and Afghanistan have no place in our streets, in our communities.
So here's where things stand right now and what you need to know. This unanimous ruling means NFA suppressor regulations have been found unconstitutional by a federal court applying the Supreme Court's own Bruen framework. The DOJ has reversed its position and is no longer defending these regulations. But this ruling is not the final word. It will be appealed until a higher court affirms it or the Supreme Court takes it up. The NFA suppressor regulations remain technically enforceable. Do not go out and buy a suppressor without a Form 4 and a tax stamp. Thinking this ruling made that legal nationwide, it has not. Not yet.
The Supreme Court is back to hearing arguments in a controversial case dealing with the Second Amendment rights of those convicted of domestic violence.
We've done $750 million just for school security since 2019.
We're ready to take on every avenue possible to make sure that this law gets blocked and that Virginia citizens have the right to keep and bear arms.
I bill the mental health access and gun violence prevention, which increase access to mental health treatment in this bill.
What it has done is create the strongest legal foundation for challenging NFA suppressor regulation that has ever existed in American law. It is backed by the government's own admission that its previous position was constitutionally weak. Watch the appellate courts. Watch for cert petitions. That is when a party asks the Supreme Court to take a case and watch that concurring opinion, because the theory it advances could reshape your rights far beyond suppressors. That is it for today, folks. See you in the next video.